Drunk driving is known as driving while intoxicated in New York and may be called DUI, OWI, or OUI in other states. The least serious form of DWI is driving while ability impaired, DWAI, and is punished as a traffic infraction. The person's ability to operate a motor vehicle is impaired by the consumption of alcohol. DWAI commonly involves cases where a breath or other test results in BAC, or blood alcohol concentration, of more than 0.05% and less than 0.08%. The maximum punishment for a first conviction of a DWAI, which is traffic infraction, a fine of up to $500 plus court and DMV surcharges, a 90-day license suspension, and up to 15 days in jail. Being sentenced to jail with a first-time DWAI conviction is very rare. To repeat, DWAI is not a crime in New York, and a conviction will not result in a criminal record. There are several different kinds of DWI involving alcohol and drugs that are crimes. The first is known in New York as DWI by per se intoxication. A breathalyzer is commonly used for this test. A 0.08% BAC is known as per se intoxication and is often referred to as the illegal limit in New York, but it's actually the illegal floor. BAC of 0.0799999 to infinity is the illegal limit, though that reading would be evidence of DWAI and common law intoxication. The second DWI for alcohol in New York is called common law intoxication, which is operating a motor vehicle while in an intoxicated condition. A driver is charged with common law DWI when a chemical test is refused or a BAC reading is at least 0.08%. In a refusal, common law DWI is proven beyond a reasonable doubt by the observations of police, coordination tests, which are videotaped in New York City, and/or standardized field sobriety tests. Police also rely on the observation of signs like watery and/or bloodshot eyes, slurred speech, unsteadiness on feet, and odor of alcohol. It is also illegal to drive when one has taken drugs or a controlled substance, known in New York as DWAI by drugs, which is also a misdemeanor. DWI, whether per se and common law, and DWAI by drugs is a misdemeanor. If convicted, a person will have a criminal record. New York does not expunge criminal records, so a DWI conviction will result in a permanent criminal record. For a first conviction, the fine is between $500 and $1,000, plus court and DMV surcharges, probation of up to 3 years, license revocation for 6 months, up to 1 year in jail, and an ignition interlock device on any car that you own and/or operate. A first-time DWI offender in New York with a BAC of 0.18 or over is charged with aggravated DWI. For an aggravated DWI conviction, which is also a misdemeanor, the penalties are more severe. The fine is increased from $1,000 to $2,500, a license revocation of at least 1 year with a discretionary second year, but the maximum jail sentence remains 1 year. Felony DWI is most common in one of two cases. First, a prior conviction for DWI within the past 10 years, or second, a first-time DWI when there is a child aged 15 years old or less who is a passenger, which is also known as Leandra's Law. If convicted, the fine is between $1,000 and $5,000, plus court and DMV surcharges, probation of up to 5 years, a license revocation of 1 year, which the court may extend during a period of probation, an ignition interlock device, and up to 4 years in state prison.